All right. Good afternoon, or I guess we're not afternoon yet. We're still morning. Good morning, everyone. Jim Bordeaux, Director of Public Relations at New Direction Family Law, here again with another Family Law Uncorked, joined today by one of the attorneys and partners at New Direction Family Law, Sarah Hink.
Hello and good morning, late morning. Who
Late
knows
morning.
what time it is these days, really? What day
We
is
don't
it?
know days, times, weeks, what month is it? We don't know what's happening.
Tuesday, April 7th at 11:34 a.m.
I like it. There's your daily reminder of what day it is. We all need that.
Yeah.
So we've had a couple of glitches. We've had to reschedule this a couple of times due to technical difficulties, internet issues, but here we are. It's finally working for us. And we think this is a very, very important topic. April is Child Abuse Prevention Month, and we are avid supporters of bringing awareness to that issue and support in our community for the elimination and prevention of child abuse. And so with that, we thought we would discuss a little bit about emergency custody, especially with the current climate of people trying to understand custody exchanges and where the courts are right now. And fortunately, emergency custody is something that is still being heard in court, correct?
Correct.
Okay.
That is one of the few cases that they are going to hear in person if need be, the return for that. And we'll go into the procedure and how that works.
Yeah, definitely. So we wanted to shed some light on exactly what emergency custody is and what qualifies as emergency custody, because there might be a knee-jerk reaction if maybe someone's not following a custody order that's already in place to file for thinking maybe that qualifies for emergency custody. And we just want to make sure that the correct information is out there as it relates to North Carolina law. So starting off, Sarah, how do you know, can you talk about what qualifies as emergency custody? How do you know it's in an actual emergency custody situation?
Right. Well, the statute for custody gives us three opportunities or circumstances that you could file for emergency custody under. And that is if the child is substantial risk of harm. So bodily injury is the word used there, the term used. So substantial risk of bodily injury to the child, that there's a substantial risk of any kind of sexual abuse to the child. And the third being if there's a substantial risk that the child will be removed, otherwise abducted from the state of North Carolina. So those are three very different things. And most of the time we see people trying to file under the bodily injury prong of the statute, which, if there's a substantial risk of that, how do you define the substantial risk of bodily injury and what circumstances might there be that would allow the court to grant an emergency custody order to you? So it's across the board for the substantial risk of bodily injury. I've had cases where it's more of an extreme case of neglect, where there's parents who are drug users, heroin intravenous, that they are obviously high for a very long period of time and the child is just left to fend for himself. That's a case where there could be found to be a substantial risk of bodily harm, and it's just a risk, so you don't have to show that there has been harm just yet in most cases. But if you have a case where there has been abuse, physical abuse, and there's pictures of bruises, belts, so I've had cases where there's an actual imprint of belt on a child, and those are cases that the court will take into consideration and likely grant an order for emergency custody. But it's important to understand that you might have valid feelings that your child might be at risk, but it might not come to the level that the court is going to grant you that order. And for now, when people say that they're not receiving their child pursuant to their order because of the virus, well, that's not going to rise to the level of an emergency custody case. If you say, well, I think that my ex-spouse, my co-parent is drinking alcohol while the children are under their care, well, okay, well, we have to take that a step further. What are they doing when they're drinking? Are they abusing the child? Are they driving drunk with the child in the car? Or are they having a few beers when the child is in their care? The court really has to have details about what the circumstances are for it to be an emergency.
Okay, and now you said with the child being, potentially in harm, would that include if the child, even if it wasn't the a biological parent or custodial parent that maybe was engaging in neglectful or abusive behavior. But if there was another party that was there, a significant other or, step parent, boyfriend, another relative that was in the home, would that qualify as well potentially?
Sometimes it depends on who that third party is. So if it's someone that the parent has control over allowing around the child, so that would be a step parent, a boyfriend or girlfriend living in the house that is being abusive to the child, and you bring that to the person's attention and they do nothing about it, then that is a circumstance where the court might need to intervene and issue an order for emergency custody, removing the child from that home until CPS can investigate, until the court can have time to look into the facts and the circumstances regarding that abuse.
Okay. Good to know, because I know sometimes that comes into play as well.
And that also, who can file for emergency custody? Third parties can file for emergency custody. And to do that, you just have to show that you have a substantial relationship with the child. So a grandparent, even someone that's an aunt or an uncle that, say, there's not two parents in the picture, it's a single parent, and the aunt comes around every once in a while to check on the child, and mom's using drugs and not in a good place. Well, that aunt can actually go to the court and request an order for emergency custody, placing that child in her care, and seek custody in that case.
Okay. Good to know that we can have those third party supports too, should the situation qualify. And we tie this into April and Child Abuse Prevention Month, and awareness, honestly, all 365 days a year. But with the current public health crisis and these shelter-in-place orders, one of the unfortunate side effects that we're afraid of with all of this is the potential increased risk for child abuse and or domestic violence in the home as well. So that's, again, another reason just why we wanted to bring light to this.
And those are tough situations because you're not going to have the opportunity for that child to be seen by their teachers or by their people, or by relatives, to check on the child, to assess what the situation is while they're at home with a parent that might be abusive. A lot of times that child going to school is their only escape from the abuse. So that's tough, and it's unfortunate we don't have ways to really check on these children during this time. And I know that some people are out there doing that. CPS workers, if there's an open case, even teachers and our local professionals in the schools are reaching out to children to make sure that they're okay.
Yeah, definitely. And I've seen other things too that neighbors and communities are doing, which they especially if there's elderly or they've known elderly, which I think is a good idea. Should the opportunity present itself, is that they communicate like colored paper, and they put it in the window if green, if everything's good to go, or like yellow if maybe they're running low on groceries and they can't get out themselves or anything like that. So I think it's really neat to see the communities communicate that way. So maybe that'll spark something for this issue as well.
And at least with adults, there is access to the internet. They can even send us a message if they're in a dangerous situation, and we can help them, get resources to interact that's still open, or help them legally if we can. Even if you're just, pretending to be on Facebook and want to let someone know that your spouse has been abusive to you, that's something that we can still provide resources for.
Absolutely. And feel very blessed in this climate to be able to still assist people in that manner with everything else that's going on.
Right.
So looking at, sorry, a little sidebar. So getting back to emergency custody situations. And if you're watching and you have questions, please feel free to reach out. We'll be happy to answer those to the best of our ability. So when you are filing for emergency custody, we've talked about what qualifies, who can file. So after let's kind of talk about the process. If you have decided, you've spoken with an attorney, you think this qualifies as emergency custody, or we're going to go for it, what's the process? Since it is an emergency, does the opposing party have to be notified? Kind of walk us through that.
Yeah, the process is very important, but I do want to go back to the statute, the 3 prongs real quick. So we talked mostly about the bodily injury, and that's one that is you need to speak to an attorney to make sure that your case will be substantiated to that level. It's really hard to tell. Sexual abuse, that's pretty clear what you need to prove. And then the third one was removing the child from North Carolina. And we've had a few cases come up in our firm about this because of the virus. Say that you have custody arrangement with a young child where they do travel to see a parent out of state, and then the parent doesn't bring the child back into North Carolina, is that emergency custody? In most cases, it's not. It's not that they're trying to flee the jurisdiction. It's just they're afraid of travel because of the virus. They, or whatever reason, it's not going to amount to emergency custody in most cases. That third prong is mostly for if there's not really an order in place already for custody, and then a parent just leaves all of a sudden with the child and doesn't tell you where they're going, it wasn't expected, and you believe that that is for the purpose of going to get out of the state so the court doesn't have jurisdiction over them and can't enforce a custody order. So that's pretty specific. So make sure you're talk to an attorney about that as well when you think that the child's being removed for that reason. For the process, that is a tricky one. And I know that a lot of people try to do this, attempt to do emergency custody cases on their own pro se, but oftentimes the court clerk will express the need for an attorney. So you have to first draft the complaint or motion for emergency custody, and that's going to have to make sure that you put all the facts in there that will give the court notice as to what's going on and give them the opportunity to assess the facts and whether or not that rises to the level needed to issue an emergency custody order. So you draft that and make sure it's drafted well, because there could be an emergency situation and your attorney doesn't draft the motion or complaint in detail, doesn't allege all the specific words that need to be in there to kind of raise the judge's eyebrow that this is an emergency situation. And then the next process is to get that to the courthouse. And at that time, it depends on what county you're in, the procedure, but in Wake County, you will just need to present the judge with a signed, verified motion or complaint for emergency custody. And they will review that ex parte and without attorney's presence, meaning that they can just take one person's word for what the allegations are in that motion as being true and make an order off of that. So if they find that there is reasonable likelihood that there is a substantial risk of bodily injury to the child, they will issue an emergency custody order, placing that child in the care of the parent who asked for the emergency custody. And that order is going to be temporary. It's an ex parte order, meaning, again, just one person's word, and the other person hasn't had their day in court, the due process afforded to them. And the statute gives us about 10 days to get back in court and actually have a hearing on the matter. So that's when everyone's going to need to be in court. And to do that, you have to make sure you serve that order on the other party pursuant to Rule 4. So there's a heightened standard to serve them with this order in the notice of hearing so they have notice of what's happening. You quickly have like 10 days or less, a lot of times less, to get all your evidence in order, to get any witnesses there that you need. And that can be a task in of itself. So you got to make sure that you're prepared from day one to show up in court a week later with all the evidence you need to have another hearing on it. And you do have to go over the same facts that you put in your motion. You have to, show them to the court and prove them to the court. And the other party will be there to negate anything and put on their defense and have their own witnesses. And at that time, the judge will issue a new order if they do find that there's emergency custody, and that will be an order in place for an indefinite period of time until there's another action on custody. So
okay, and I know you. Process. Yeah, just that little bit. I know whenever we do it,
yeah.
We just get started on it, we get it done, and then before you know, it is submitted to the court. We're waiting for a response, and then the 10-day hearing is scheduled. So it kind of goes boom, boom, boom. But just listening to you describe the process to someone who has never been faced with this before, obviously is not an attorney, specifically a family law attorney, that seems really overwhelming. It seems like a lot.
I recognize that I'm an attorney who does that often and can just hammer it out and talk to you and probably eyes glazing over out there on the internet, like, what is she saying? I don't understand, have all these questions. And I think the point is that the statute allows for this process, this ex parte process, for the sake of the child, but understand that there is someone else out there that has rights to the children as well, at least during that time period. And there are cases where someone has filed up for emergency custody and have not done so for the right reasons, where there's not an emergency, or perhaps alleged facts that can't be proven at trial. And it is important to have that due process that entire procedure of making sure that everyone's rights are confirmed, and the court is proceeding under the constitutional requirements, and we're doing everything right.
Yeah, definitely. And I think, I know people sometimes, as soon as they hear the word attorney, they just see dollar signs. And, we all want to be cognizant of fees and not just throwing money away. And of course, no attorney can guarantee any particular outcome from a judge, or, what that judge is going to decide or anything. They can just represent you to the best of their ability. But, just listening to you talk about the procedure, if you're going to do this and you're doing it, for the protection of whatever child you're filing this for, I mean, really, really want to make sure that you do it as correctly and, with as strong possibility as you can going
Right.
before the judge with this. So just kind of another ode to really, I know, like I said, people like to save money, but having that attorney representation and really maximizing your chances of getting that granted from the get-go. It's just something to really be mindful of for anyone, watching or considering, or if you ever come up with a possible emergency custody situation in the future.
Yeah, and everyone's case is different. Everyone's circumstances are different. Everyone's facts are going to be different. So it's important to have the attorney be able to go out and look at case law and cases in the past and saying, well, the court found that this was a substantial risk to the of bodily injury to the child, that these sort of circumstances were, or on the flip side, having an attorney represent you to defend that motion for emergency custody. Say, judge, this isn't an emergency situation, and the courts have repeatedly found that this is not an emergency situation. So it's important on both sides to have an attorney, have representation, have someone knowledgeable in this area of the law, because if you're going to get an order out of all of it that might last for a year or two, and that's going to be an order that other judges look back on and say that this happened, you really have to protect yourself.
Yeah, absolutely. And I'm glad you mentioned the other side too. I think when you originally think of it, you think of the one who's initiating the emergency custody action, but absolutely for the opposing party, the person that's not initiating, to make sure that they're protected too, and that their voice is heard, and that everything's being done correctly. So I'm glad that you mentioned that as well.
Yeah.
I know we work in surrounding counties Wake County and surrounding counties. But would you say, I know we don't have a whole lot of control over what judge gets assigned to the case or what judge is going to review the potential emergency custody order. But being familiar with the county that, that you're in, that this action is going to be filed in, and the judges, I should say, like in family court here, can you speak a little to, is there, having experience with the judges as to what they particularly look for in an order? Do they have like a style, so to speak?
Certainly, because it's all in the discretion of the judge there to award the emergency custody. So if you work with the judges on a constant basis, you learn what kind of cases are going to get signed by one judge, what level do the facts need to be, as opposed to another judge who will grant emergency custody in these kinds of cases. And then with other counties, it's more of a procedure difference. And in those counties, in smaller ones surrounding Wake County, you want to make sure the attorney takes the motion to the courthouse to be filed, because in those counties, sometimes the judge actually wants to hear from the attorney filing the motion and may have some more questions, and not just take the pleading for what it is and read it and make a decision just based on the writing. They actually want to have someone there to ask questions like, oh, okay, say this in your pleading, tell me more. So you need to make sure that you have an attorney who will take it upon themselves to call the clerk, see the procedure in that county if they're going somewhere out of county, that they understand that it is a case-by-case basis and that each judge is different, each case is different, and take the time to get to know you and your case and know the judges and the court procedures in the different counties around here.
Yeah, good point. And I don't know, like I said, with Wake County, and correct me if I'm wrong, but you don't know who the judge is ahead of time. So before you file for emergency.
Most of the times, if it's emergency custody in a case that's already been pending, so there's already been a custody order, then you've already been assigned a judge. But if it's a new filing, a new complaint, then you'll get assigned a judge at that time.
So let's now just moving through everything. So let's say you filed the emergency, or your attorney has filed the emergency complaint for you, emergency custody was granted, and now maybe you need to go get the children from their unsafe environment, or from, pick them up from school, or whatever the case may be. Will law enforcement assist you in making that happen if need be?
Yeah, it depends. So, and everything I'm saying, there's always caveats to everything because I cannot just sit here and talk about every different circumstance to every different case. That would be a really long and boring Facebook Live. But that comes into the procedure now. There's been some changes in asking you have to get law enforcement to help you. You have to make sure that you ask for it in your initial pleading. And judges want to see now, this is now actual live testimony from someone asking for the law enforcement assistance and issue an order to law enforcement to aid in that transfer of the child. So that is a very technical aspect of these cases now. Before, you could get an order that would say it. You could just ask the judge for it in your pleading and just pop it in the drafted order, and the judge will order it. That law enforcement are ordered to assist in this. And even then, sometimes officers are hesitant to get involved in custody cases. They often say, well, this is a civil matter. So it's also going to depend on where you end up with law enforcement and the sheriff of that county and their procedure as well.
Gotcha. So there's definitely a lot that can go into it. And I think, again, just talking about the different elements of the law that qualifies for emergency custody just speaks even more to the importance of one, consulting with an attorney. I mean, obviously we advocate that you have an attorney represent you, but even if someone decided to go file or initiate an action on their own, bare minimum doing a consultation with an attorney. I mean, specifically for our office, the process would be to set you up for an initial consultation. I would be virtually or via telephone during the current times. And that's really going to help them determine, having an attorney listen to the situation and help them determine if this qualifies as emergency custody. Again, not being able to guarantee that the judge will decide one way or the other. But at least that's a good starting point that can help navigate you as to, what the next step should be.
Right. And there's opportunities to look in the past to show that this person has the tendencies towards violence. So that might not be something you think about on your own. And an attorney is going to sit down with you in that consultation, ask you certain questions, and other things might come to mind that you didn't think about.
Definitely. Well, I think this has been very informational. I hope people have, they find a benefit from watching or listening. Any final thoughts as far as, consideration of filing for emergency custody, especially during the public health crisis?
Yeah, I think you covered it with just consulting with an attorney, whether that's one of us at New Direction Family Law or someone in, closer to your home if you're in a different part of North Carolina. And of course, if you're in a different state, please talk to an attorney in your state. Their statute is likely to be different. So this is just North Carolina based, and I'm speaking from someone that practices, Wake County and the surrounding area like Johnston County and Durham County, Orange County, Harnett County, those places. So it really is different county to county and definitely state to state. So speak to an attorney, make sure you have everything in order, and keep protecting your children out there, and watch out for other people's kids during this time. If you see something, don't be hesitant to say something to, the non-emergency police line. If you want to report something, reach out to Safe Child in North Carolina, and you can find their information on our page, I'm sure, just to keep an eye on the children out there for us.
Yeah, absolutely. And especially during this time, the Prevent Child Abuse in North Carolina has a campaign going for Child Abuse Prevention Month with Connections Matter. And across the board, it is a great campaign, but especially now with the change of events with the virus and these times, it really is important for us as a community to look out for one another, look out for the kids, and provide that protection where we can. In line with that, we do have another Family Law in Court scheduled for tomorrow, actually tomorrow afternoon, with Kristen Duranje, the Executive Director of Safe Child, which is a local organization here in Wake County that helps to prevent and eliminate child abuse. And we'll learn about all the awesome programs they have and how they're approaching the increased risk of child abuse and what resources they're providing as well. So Sarah, thank you for joining me from afar. Yeah. And, guys, keep on tuning in to our Facebook Lives. We'll have more information coming your way. And as always, if you have any questions or need to speak with an attorney, please don't hesitate to reach out to us and we will get you all squared away. So until next time, have a good day, and we'll see you guys next time.
Yeah. Bye, everyone.